about to open up the dialogue, open up the debate, and reveal where some of the fissures are, some of the lines that have to be clarified and maybe dealt with before we move forward. I just want to introduce to you Mr. Justice John MacMenamin from the Supreme Court of Ireland. He's going to chair this morning's proceedings. We're absolutely delighted and honoured to have you with us. It was once said, in fact, there's a book with this title, that Justice Oliver Wendell Holmes was the Yankee from Mount Olympus. And we like to think that some of our judges qualify to occupy at least some small space in Mount Olympus, and certainly Justice MacMenamin is among those, because he's fated to really enter into a difficult terrain, which is to unfold the majestic generalities of the law, but also to confront some of the raw edge of human experience and try to make some wise decisions navigating between those two shoals. So there could be no better person really to try and draw out some of the problematics, clarify them, and then hopefully shine a light for the way forward. We also have one other addition to the panel. Well, we have several additions to the panel, but you know most of the people. The one person who hasn't been formally introduced to you is Dr. Ignacio Campuy from King Carlos III University in Madrid. I can never remember if it's the third or the fifth, sorry, it's the third. And he's really an expert in the rights of the child, and he's backed into disability law in terms of revolutions in legal capacity and working it back into the realm of the rights of the child to see what kind of implications there are for children's legal capacity. So without further ado, I hand you over to Justice MacMenamin.
Jared, thank you very much. First of all, it's customary to say at a meeting like this that it's a great honour to be here. But when I say it is truly a great honour to be here, I mean it. Because this is truly a centre, a world centre in this field. And it is inspiring for somebody like me who engages in the area of law to see a group of people coming together from all corners of the world to participate in this very, very important issue. I actually have some slight credentials in the area because I was a High Court judge until a year and a half, 2 years ago, and I did have to actually wrestle with the case which dealt with Article 12 and its status in Irish law. But what I want to do is get away from Irish law, the Irish Constitution, and talk a little bit more generally, and ask people to talk more generally, dealing with the issues which I think have been addressed by all the speakers. And I think that the general issues come down to questions like, what does it mean to be a person? What does society mean? Does society have rights when we're dealing with Article 12? How do we balance the rights of autonomy on the one hand and the rights of society and rights of people close to individuals who suffer from a disability? There are some of the questions that judges have to face. Because the difficulty is that in our particular domain, we tend to deal with harder cases which are not so easily resolved, and where concepts such as equality sometimes are difficult to realise in actuality. So that, for example, when one comes to dealing with issues such as substituted decision making, questions may sometimes arise as to how do you achieve substituted decision making when a person who is at the centre of a law case may wish to make a particular decision which a court applying the best interest test, the old-fashioned best interest test, may feel is not in their best interest at all and may actually be life-threatening. So that's one side of the equation. The other side of the equation in the discussion, I think, is when one tries to apply the precepts of Article 12 balanced with Article 16, to what extent does experience show that old tensions arise in a new guise? And does one reach a situation where the paradigm shift which we're seeking to achieve is one which is a paradigm shift in attitudes, but when it comes to the sharp end of very difficult cases, is difficult to achieve when you're looking at the consequence and when you're looking, as courts have to do sometimes, at the orders that have to be made. So what I'm going to do is ask questions like that. And of course, can we have a situation where the law can be value neutral? Can we have a situation where the law should be value neutral? Should we have a situation where autonomy is something which is moved to a position where the balance is so shifted that society may decide in the long term that its attitudes to an individual may change, or its duties to an individual may change? I think there are some of the difficult questions that we have to deal with. How do we deal with classification? Lawyers are always dealing with classification. Is the very process of classification so dehumanizing as to create difficulties when one looks at the whole process, the whole concept of autonomy? Now, these are all issues you've all been touching on, and what I want to do to start off the discussion is to ask Lucy, who has experience of the UK Mental Health Act as it has operated, to deal with some of those issues and to ask and to address some of the questions, particularly perhaps, are we dealing with old tensions in a new guise, on the basis of what many people regard as being the best effort yet to achieve the paradigm shift. And from then on, I'm going to ask everyone to participate in the discussion. The microphone will be available somewhere. There it is. And I'm going to try and be fairly fascistic because I want all the audience to be able to participate as well. So if people go on too long, the panel be warned. I'm going to sort of knock on the thing in a very judge-like fashion to make sure that all of you have a right to participate as well. Okay, so Lucy, I've asked some hard questions. How does the UK Act work, and does it work?
Well, I don't want to bore the audience with a repetition of how the Mental Capacity Act works, because I went into that yesterday. But I understand your question to be, is it the best effort yet? And I suppose it's very clear to me, and I think to most people who understand what Article 12 is about, that the Mental Capacity Act isn't compliant with Article 12 CRPD. This is because it incorporates a mental capacity test to give effect to a legal capacity. So people with disabilities are forced to satisfy certain criteria in order to claim their legal capacity. So the question really is the Mental Capacity Act the least bad effort that we've yet seen? I haven't done a comparative study of all different jurisdictions, but I suspect that actually other systems may well hold better frameworks, less bad frameworks. I think it's important to understand the context into which the Mental Capacity Act was created. Elizabeth did a great talk earlier today about the informal loss of capacity. In the United Kingdom, we have this historic power of the court called parens patriae. So the court can make decisions on behalf of people who are called lunatics or idiots in the unfortunate terminology of the past. This was abolished in 1959. We also had a relic of a system from the Mental Deficiency Acts of the kind of eugenics years of the 1930s, which was called guardianship. In 1983, thanks to quite a powerful civil rights movement, the powers of guardians were massively retracted. So in 1983, at face value, there were really no formal powers to deprive people of their legal capacity to make health and welfare decisions, so decisions about where they lived, who they lived with, and so on. But that didn't stop practitioners and carers from helping themselves to that authority to deprive people of these choices. So people with disabilities were deprived of these choices on a widespread basis, even though there was no formal authority for that in law. So when the Mental Capacity Act came along, what it did was regularise and legitimate what was already happening on the ground. It also created a mechanism for a small number of people, the kind of articulate people that I was talking about yesterday, to say, well, hang on, I do have this thing called mental capacity. So it did help a few people reach out and grab back their legal capacity. But that isn't what Article 12 is about. It's not about helping a small number. It's about helping everybody to reclaim control and power over their decision making. So there is a reason why the Mental Capacity Act is said to be empowering, and that's because in some ways it provides a mechanism for some people to claim back their power after this informal loss of capacity. But it's a really inaccessible route, it's not accessible to most people, and it doesn't really build into it this kind of idea underpinning Article 12 about supporting people to really realise their potential for what Gabriel was calling self-determination. The other thing, this is quite a good opportunity for me to mention this, is even within the UK, where the Mental Capacity Act is pretty popular amongst particularly social care and healthcare practitioners because it gives them quite a lot of authority with very, very few safeguards. There is real growing concern about the Mental Capacity Act, and the House of Lords has literally this year appointed an ad hoc committee to conduct an inquiry into its human rights compliance. Now this inquiry isn't some really radical inquiry, they're actually concerned that the Mental Capacity Act contravenes really basic European Convention standards. But it is of course a great opportunity for us to inject some CRPD debate, because that debate isn't happening enough in the UK at the moment. There's also been a second inquiry opened in this last week by our Equality and Human Rights Commission, because there is growing concern that the Mental Capacity Act is being used to deprive people of their liberty in social care institutions and in hospitals with totally inaccessible safeguards. So, no, I couldn't comment on whether it's the least bad option, but it's certainly not the best we can imagine.
Yeah, Leanne, how do you feel Article 12 can operate in hard cases?
It's a big question, isn't it?
Yep.
Ignoring the technicalities about international law and domestic law. Good.
We'll just get to the nitty-gritty here. Yeah.
Okay. I think having a clear statement of legal capacity for all people in the Convention, if it's brought into domestic law, gives a powerful defence in hard cases. It opens up a, well, let me talk a little bit about that case, Patrick's case that I put up as a case study, PJB. It's actually under our Victorian Charter of Rights and Responsibilities. In that, this is the case of the man who was held in involuntary detention as a mental health patient, and where the hospital wanted to move him to a hostel and he didn't want to go, and they wanted to sell his house because they saw him having somewhere else to go as being an impediment. And they persuaded the relevant tribunal that he was incompetent under the Mental Health Act, so therefore he lacked legal capacity, and that it was in his best interests that the house be sold. The case went to the Victorian Supreme Court, and one of the things that the Charter does is recognise the human rights of people with disability. It has a non-discrimination clause in it. And the judge in that case was able to use human rights principles coming out of the Charter to acknowledge that while the man was lawfully detained as an involuntary patient, there were no grounds whatsoever for taking away his power to deal with his property and to retain his home. So having something like Article 12 provides a tool for self-advocates, for advocates and for judges to look at, well, to uphold people's rights, but to consider the issue of legal capacity in a different light. Having said all of that, and I know you wanted me to talk about the positive hard cases, I think that the theme that's come out in Liz's talk and in some things Lucy said, in lots of the talks, is the fact that we can have very clear, very good law, but if we don't change people's attitudes, then the hard cases can actually go the other way.
Okay, thank you.
I could maybe add to that myself.
Yeah, sure.
Hard cases is always a great question, that as soon as you convince people that the right to support exercise legal capacity is a real thing, they jump straight to the person in the coma, the person making a life-threatening decision, and so on. And I think it's really important to actually talk about those, because these are real situations, they're not made up, and these are things that judges and people on the ground have to deal with all of the time. And I think partly this is why things like the Mental Capacity Act exist, although I would agree with Lucy that I don't think that's the best way of addressing those. Anna and I had actually wanted to get into some of this yesterday when we ran out of time. We had thought about a number of scenarios that are real cases that we could potentially discuss. So there's one which Michael Bach often describes, and I think he described last year when he was here at the summer school, which is a young man, an adult with intellectual disability, who is in severe pain, has a rotting tooth, but is also really, really afraid of the dentist, as many of us might be, and does not want to go to the dentist to have the tooth removed. And his mum, who knows him very well and knows the way that he communicates, which is not through speech, says, I can tell he's in distress, I can tell that he would like the pain to stop, but he will also physically resist if there's any attempt to bring him to the dentist. So these are one of the examples that are given about, well, how would a right to support and exercising legal capacity work there? What could you do other than impose a guardian on that individual or make a substitute decision? Do you want to talk, Anna, a little bit about things you could do?
You notice the way they're taking over. Do you see that? don't think I'm not unaware of this. Go on.
Quickly, I think, and Michael might actually answer this a little bit differently himself, but I think the really important thing is that shift from will and preference from best interest to will and preference. So instead of kind of allowing all the things that you've heard around that person to control what happens in that situation, so the mother says he's in pain, I know he's in pain, but he's very scared of the dentist, and he needs to go to the dentist. So that's the information we have. We actually haven't been given the information about the individual himself, why he's reacting this way, from his own perspective, not from his mother's, and what could be done to create a situation in which that's optimal for him. And there's actually so many things that can be done. Get a different dentist. Maybe he's scared of one particular dentist that he's been with. Or make sure there's a dental hygienist that he really, really feels comfortable with. Or do as much as you can from the home, depending on what actually needs to be done. But the really important thing that I think Article 12 brings us is an obligation to not look at what's around the person and what we think the result needs to be in the situation, but instead to look at the actual individual and what can be done for that individual, what support can be provided to allow him to be able to do what he actually wants to do, which might very well be relief from pain. But he just needs the right situation around him to have that done, and unlikely forcing him into a traumatic situation with a dentist he might be afraid of, in an environment he's afraid of, can do more damage in the end than leaving the tooth, maybe. There's lots of other issues around this. I don't know if anyone has other comments or if you want to move on. I hope that helped with the discussion.
Could I just ask another question? Looking at it from the point of view of the United Nations introducing Article 12, was there a tension in trying to bring in what might be seen as top-down, in other words, establishing a principle and then trying to apply it among all the member states? Because the law operates in a way which is induction. It moves from the individual facts to principle very often. And The difficulty about that is sometimes when you try to apply principle to the individual facts, it doesn't fit. So, can you help me there?
I assume this is directed at me. Thanks, John. Yeah, it was about establishing principle. This is what was seen as being, a fundamental move in the way people with disabilities were conceived. They were to be embedded in international law as rights bearers, as rights holders, as people who are recognised in a legal sense. And so it was about enshrining personhood. So having to establish that in international and human rights law, and then not have a clear statement of equal recognition before the law contained within the operative articles. So it was very much about establishing principle, but you're quite right. There's the chicken and the egg situation, because fundamentally Article 12 is only ever going to really, really work when we get all the other elements of the convention to work. Until people with disabilities are living and participating as members of our community, we won't get the attitudinal change, and we won't have the mechanisms where people don't question the decision-making or the legal capacity of a person with a disability. So yes, it was a bit top-down, but it was a way of creating the situation that we've got, this type of forum. This conversation is being had, this discourse is being had around the world. So there's movement, there's the opportunity for it not to be so top down that now grassroots is embracing it, that will get some bottom up and that sort of hands-on experience that Anna's talking about, problem solving and looking at the ways of not what should be done, but how things can be done.
Okay. Does it make a difference? Can you actually say, yes, it makes a difference to the bottom line decision that comes out of a case if it comes to a court case? Or does it just affect the process?
No, it's got to affect more than just the process. I mean, a court case is about 9 times out of 10 about getting an answer. And 9 times out of 10 about never getting the right answer. Or is there a right answer? I suppose, if it affects the process, that's good. But the chances are that the person with a disability is going to have a greater opportunity to have an outcome that is more in keeping with what they want if that process is influenced.
Okay, anyone else like to have a view about that, or anyone from the audience? Yeah. Sorry, is there some...
There's another mic.
There's another mic. Well, great.
I just want to raise a point there in relation to that situation. I have just noticed a point that hasn't been mentioned from the panel of a situation that I have experienced, having completed a recent project with GDO where we interviewed and were involved with people with disability and talked to their parents and key workers about situations that they're in moving from institutions into independent living. And the funding from GDO went to them, various organisations, and it was an independent advocate that got to know the person with the disability over time. It took a year or two or whatever. But I think this person in this case, okay, and I don't blame him not liking any dentist because who does? But as one of you had mentioned, it could be a thing that maybe he doesn't like the person, or maybe he had a bad experience that maybe he hurt him, in the past, or there might be some other dentist. But that's where it should be a case for an independent advocate to get to know the person or the individual over time, so that when the person knows the individual, they'll know, he'll be able to express in a way that the independent advocate will understand as to what he wants, rather than the parents. You know, because the parents are very overly protective of any child with a disability. So I think an outside independent advocate would be an idea in an ideal situation like this. And it sounds to me similar to the moot court scenario that we will be dealing with at the end of the week. So that's just a point I thought should be mentioned in the situation. Thanks.
How do we make sure that independent advocates are actually, persons engaging in supportive decision making, are actually representing the views of the person rather than actually exercising a best interest test themselves? How do we ensure that doesn't happen? Has anyone any views about that?
So this is really important, because when we talk about the safeguards that are needed for supported decision making, we're really trying to make sure that supported doesn't just become substituted at a certain point, and that is a very real and present danger. But there are ways in which you can put in place checks and balances to make sure that people are really listening to what the person is telling them and trying to put aside their own views on the situation and just represent what the person is saying. But that is a real skill that has to be developed over time, and people need support in order to be able to develop those skills. There's a really good example of the pilot project on supported decision making that was done by the Office of the Public Advocate in South Australia. And Sherry Nicholson, who was actually in Ireland a number of weeks ago talking about the project, she was the facilitator there, who worked with over 20, I think, individuals who wanted to use supported decision making, helped them to choose their supporters and decide what areas of decision making they would like support with. But she was basically the person supporters could call if they were worried about anything. So they would say, the person wants to make this decision, I feel really strongly about it, what do I do? And she would take them through the steps of how do you make sure that you're not stepping in and what she calls rescuing the person. How do you make sure that you're just stepping back, listening to what the person wants and putting that forward and not letting your, and it's a real skill. And there's lots of ways in which people need to be supported to develop that, but it can be done. And there are checks and balances and monitors that you can put in place to make sure as much as possible. But there will always be situations in which it's very unclear, especially where someone is not communicating in a conventional way, and there are very few people who understand them. Sometimes we will be taking someone's word for what they say a person wants, and that does concern me. But I think, as a whole, it's better to take that risk within that system.
The South Australian trial was very good, very interesting for that. But when they were developing the process around the New South Wales trial, what they were doing with the supporters was walking through a process where they had to be able to demonstrate to somebody else what the will and preference of the person was. So what did that mean to them, and how could they demonstrate that they take it, they do it in abstract examples, but it was a way of making them think about how to approach the will and preference concept.
And do difficulties emerge if family members are identified as the advocate, or the person supporting the decision-making process?
I think this really highlights how important it is to make sure that everyone is recognized as an individual who has standing to bring a claim before a court. Because when these things happen, when maybe a supporter represents themselves as knowing the will and preference and takes illegal action, and the person is actually being oppressed and substitute decision making is happening, that individual has to have the ability to go to a court and make sure that their rights are respected. And right now, in most jurisdictions, most people, a lot of people with cognitive disability and physical disability has been brought up, don't actually have that access.
especially when they have someone supporting them to make decisions.
But Elizabeth, yeah, isn't there a difficulty which can sometimes emerge because a family member can legitimately say, I'm the person who knows the person best. I know what they want. I know what they're seeking to communicate. And yet, on the other hand, you could be getting very mixed messages and you might not be getting the correct message at all. But maybe I'm asking you a question, you wanted to deal with something else. No, go ahead.
Maybe Anna wants to respond to what.
No, you say what you wanted to say.
Yeah, I mean, what I wanted to say was that in our context, we don't have independent advocates in that sense, but what I've seen happen is, for instance, one of the members of a disabled people's organizations called Users and Survivors of Psychiatry, the doctor said that she needed to go through ECT. At that point, what she had indicated was that she'd like her husband to support her in making those kinds of decisions if she's in a crisis. So what he did, instead of what usually happens, which is that families just quickly sign the form, is that he went back to the peer support system that has been set up by the Users and Survivors of Psychiatry. So there was a discussion where people who have gone through ECTs gave their views to the husband, and people who have declined gave their views to the husband, and so this deliberating took about 2 weeks before they reached the decision. So in other contexts, it's really DPOs and sort of peer support mechanisms that come in.
You gave an example this morning, and I was fascinated by it because it seemed to me to identify some of the problems. You have a family member who's not taking their medication, and the family say, that's your choice, that's your autonomous choice. But our autonomous choice as a family is we can't have you living with us anymore. And it seems to me that's a classical example of the difficulties which can emerge.
Yeah. I mean, that difficulty emerges a lot, and in the focus group discussion that I had, that came up, and the saddest part of it was that even the husband to one of the ladies who was present there, while he said that he insists that she takes medication, on the other hand he said to me, I'd like to know, does taking this medication have such serious side effects? Because when we got married, she didn't have a physical impairment, but after 10 years of taking this medication, she's almost paralyzed on her left hand. So, it's very, very complicated on the ground.
Yoshikazu, in Japan, have you no, this way, thanks. Yoshikazu, in Japan, have you had that kind of experience as well?
Yes, Japan, traditionally, Japan respect on family position, and so doctors or psychiatrists usually ask family's opinion. And so, for example, involuntary hospitalization, after involuntary hospitalization, doctors, psychiatrists ask, so parents or spouses to accept the hospitalization or not. And so we advocate strongly against such kind of situation because family members often have interest conflict, and so we are against such kind of situation, and we run some educational project for family members in such a situation. We recommend some principles for families at such situation. For example, you should follow best interest or substitute judgment, or the least restrictive alternative, or the most inclusive situation, or such kind of that. And some family members are so much educated, and so they follow such kind of principles. And the situation is getting a little bit better, but we have still a lot of impatience now. It's a problem.
Okay, so now we have two other panel members, and I'd like them to contribute from their particular backgrounds.
Yes, the issue of families emerges very often in Serbia as well, because family has a very important place in a person's life. And but we have to go back where that paternalistic approach led us. So for acting in the best interest, and I believe that the leading role was actually led by families and family members to protect individuals from harm, led us to this paternalistic system that we have worldwide, and that is that people are denied choice. So we really have to shift how we look at a person, and that it's the matter of really paying attention to what a person has to say. Because yes, families may be acting in the best interest and maybe know what that person wants, but we have to think beyond that, and how will that person live when there is no family to support her or him. So we have to set up a system that will actually ensure that the will and preferences of a person are respected regardless whether that person has a family or not. So
but does that sometimes mean that you might be exercising a best interest test? Because if you have to explain to the individual, the choice, I call them the choice maker, the person who has to make the choice. Your choice may have certain consequences, and one of those consequences is that your family may say, we don't want you to live with us anymore. Are you not in effect negating their autonomous choice-making capacity? Because really what you're doing is you're engaging in guidance, because you're saying, look, think of the consequence. Now, on the other hand, you'd say, but are you not entitled to do that so that people think through their decision? How do you balance between autonomy and perhaps guidance or posing issues for people? I don't want to exclude Carlos either.
Okay, Ignacio afterwards. I think it's important to bear in mind that Article 12.4, the contentious article that Rosemary was describing yesterday, does say that supports for the exercise of legal capacity must be free of undue influence. Now, it can sometimes be very difficult to distinguish between support and undue influence, but that's not an issue that's made any different by avoiding a substituted decision-making paradigm. We find that problem under the Mental Capacity Act all the time. We find that problem in case law on undue influence that has nothing to do with disability. That's a problem in human relationships, the problem of other minds, as philosophers would call it. I'm not sure that keeping a best interest standard makes that any easier.
Carlos, do you notice the way I'm preserving equality so that everyone gets a say? It's important.
No, what I think I have to start is to say something about the Spanish model, because if not, it's not going to be understood what I want to say. At the beginning, we want to differentiate that there is a capacity of legal capacity, but it means that you are a holder of rights, and capacity of act. No? Yesterday we were talking about that. That is, you can exercise your rights. So at the beginning, you can go to a process, a judicial process, that can make you incapacitated to take decisions about your life, because they think that because of your disability, you can't take decisions on your own life. You can't manage your life, so they can incapacitate you. In this sense, for the family, what usually happens with some person with disabilities, when they are child, they are under the power of the parents, but when they grow, they can go to this judicial process, so they can be say that they are incapacitated person, so the parents start to be the tutors of this person. So at the same is the same paternalist measure. You before you are like a parent, you take the decision for the best interest, and after you take the decision for the best interest, but because you are their tutors, but it's just the same, you know. So we are moving, and we are thinking that we have to, this is not Article 12 at all, so we have to change, but at the end, neither, not the judicial power, not the government, not the legislator, think that they have to change very radical. They think that with some measure that we can take, it's all right. even there is a sentence of the Supreme Court in 2009 that said that. In Spain, our model is okay with the Article 12 of CRPD. And also the answer of our state to the committee question of what steps are you taking to change your model, they say, well, our model is okay with Article 12. So this is a problem because I think it's not very good to understand what it means at the reality, Article 12.
Okay. Eleanor, were you sorry, yes, you're...
I was only going to make one very small point. When you talked about, well, what if someone's family is going to say, well, that's okay, but if you make that decision, then our decision is not to allow you to live with us. And I just wanted to bring back to what Rosemary said about we can't look at Article 12 in isolation. Article 12, if we could introduce the best, most Article 12 compliant legal framework tomorrow, and it wouldn't matter if people didn't have real choices in their lives in practice. Because if people don't have good peer support, if they don't have good community living options, it doesn't matter if they get to make their own choice, because they're getting to make choices between really bad alternatives. That's all that they've got.
Forced choices, yeah.
Exactly, forced choices. So I think that's why we need to think about realising Article 12 in conjunction with all the other articles of the CRPD, and not thinking that although Article 12 is really important and touches on all of them, it's not something that if we just solve Article 12, everything else will happen. It all has to be done sort of together, even though that is a huge challenge.
Okay. Anyone in the audience like to make an observation? Yes. I'm sorry for pointing, but somebody, third row up. No, sorry. I'm going to, I'll come to you later.
Okay.
Okay, thank you. Thank you, Chair. I want to pick up from where Elena really left off, because even in the African context, just like Elizabeth trying to really marry the CRPD, forge a marriage between the CRPD and the realities of the African context. I'm seated here thinking, maybe the solution to all this is actually empowering the person with the knowledge, the ability to communicate, and as we try to implement all the other articles of the convention. Because look at us in Africa, Uganda, Kenya, and so on. The person with disabilities is born. One, your father will leave the home because this woman has come to me with a curse. She's bearing me disabled children. Then you're not taken to school. So how are you going to be able to even learn anything and be able to make a very informative decision, even as in your own capacity as you, the person who is disabled? So you will move away from having no education at all. You cannot even have an employment. You cannot even begin talking about having property, income, and money for somebody to come and help you manage, because you don't have anything and you don't even have an education. So it leaves you with just the family system. That's how the family ends up being your everything, because the family has not empowered you to be yourself. So not until, for me, I think not until we break through, that's that door, we need to open that door to empowering the person to be able to learn, communicate, understand, and form their own person and make their own decisions to communicate to the family and to everyone else. For me, I think that is the solution.
Okay, thank you. There's another contributor up there. I promised I'd come back to you.
Thank you. I think it's a very poignant example that you just discussed about the conflict of interest between a parent who's the representative of someone who is receiving supported decision making, and they live with them and they're also their representative. I understand the point that full implementation of the CRPD would be needed to make sure that there are safeguards against any undue influence there. However, in a real-world application, it's very unlikely that the entire CRPD will be implemented all at once. So I wonder, maybe when Article 12 laws are being introduced and crafted, if it's a good idea then to maybe have a safeguard where the person who is the representative of the person concerned cannot be the person who controls the living environment. Otherwise, there's this situation where it always says, do what I want you to do, or else there's the door, or in the reality of people with disabilities, do what I want you to do, or else here's the institution. It seems like there's that looming threat. And so how in crafting legislation in a non-perfect world can that be safeguarded against? Thank you.
Okay, would anyone like to? Yes, yes. Sorry, is there somebody with a microphone come down to the front there, and then I'll come to you.
I just want to ask if you have heard of any examples where maybe there's a parent who is taking the responsibility, if they can get some advice from other disabled people. Because if I think of myself, if I was helping someone else, maybe this isn't for me, I would probably want to be my parents, but I would definitely want someone with disability or someone that has similar experience to understand, because there's so many things that maybe some people don't understand, like, you know, how it is to receive assistance and something like that. So I just want to know if you have heard any examples where the same people themselves have been involved in this process.
Okay, thank you. And sorry, I promised I'd come to you next. This person in the front row, second row.
Hello, I think this is very interesting. I have 2 children with disabilities, and they are also difficult communicating. You know, my youngest, she's 20, she don't have words. They are, yeah. So my experience, you are talking about the parents are both the worst and the best. So it's very, very difficult to be a legal guardian to, how do I know what's the best? But my experience is that the municipality, the social workers and the psychologists, the doctors, they say, oh no, you can't apply for personal assistance. No, they can't live alone. No. So I think the discussion about the family, yes, I can see the family is the worst, but I think primarily it's the best because they know how, they know the setting, they know the child and the person from childhood until adulthood. Who else does that in our welfare system in Norway? I'm not talking about Africa, but in Norway. Thank you.
Somebody up in the very back row there, I see. Very, very back row. And then I see somebody else in the back row while you're up there, so we save you a trip.
Well, I want to raise, and maybe, I want to listen to some comments about how to build this balance between independent advocates and family members. Because what I feel is, of course, we can think for one side that, okay, we have to build community, everybody will have natural supports, everybody, will be free of prejudice, and people will, flourish naturally. But the other side will say, okay, family members will have conflict of interest, some of them, or maybe often they have a lot of a protectionist impulse. So, but my concern is building, a structure of service provider for support decision making or for independent advocates. It's not gonna, throw us again to the same point when we started, with a big structure for support decision making, but isolating the person from their families and community, because what I feel is, when I'm gonna take it personal, that when I decided to, for instance, 8 years ago, no, it was 5 years ago, drug medications. My family says, that's a really, really bad idea. And probably they were right. But it was my decision, and it was better for me, but not better for them. And actually, probably they were right. There wasn't better for it. But I think life, you always will find these conflicts. That's natural, you know, because what is good for you is not going to be normally good for the closest person around you, because that conflict will arise because they know you better. And I think we have to deal with that. And we have to put the balance just to mediate in this relationship that will flourish through life. But my concern is how to avoid to build a new service, a new structure that will drag of us again to the point we started.
Okay. Speaker in the front row, and then I'll come to you up at the back, okay?
Just a quick point. I'm a PhD student here in the centre, and my PhD is related to both Article 12 and Article 19, and also user-led service. So I'm going through the triangle of where this is going, really, you know. But more than that, I want to say that 10 years ago I started university, and my younger book, by Kukamsiya, in the same sense that then in 2003 I moved out to an apartment in Galway, and my parents had trepidation, anxiousness, that everything would work out for me, but also they made me who I am, so they made me appreciate the right of making a mistake, learning by that mistake, and hopefully not doing the same mistake again. You know. But no, that is the single most important gift my parents ever gave me, the right to make mistakes. Because it's by those mistakes that you learn. Same as the government have made regular mistakes with people and regular mistakes with their lives. Same with the judicial system in that sense, in that they don't understand what it is to live with disabilities, or even, you know, like the college often run them, like these days of like going around in a wheelchair and like giving people examples of you know, various disabilities and how hard it is. But they get out after an hour. Even through my PhD and the historical context, those are things I have to write about. But then I go home and I still live with a disability. So the end of it is we have to do all three. We have to make the government aware of their responsibility to put resources in the right place. Then we have to make the legislative adjustments, which I would have a preference towards a Personal Assistance Act, which defines the role of a person with assistance, which takes it away from independent living, because the phrase independent living is to live entirely on your own, which nobody ever does, right? So it goes back to that point. Anyway, so that was a quick summary of where I'm at, and I hope I explained some of the points that I'm dealing with, and I have difficulty marrying all parts of my life, but all the parts of my life define who I am, who I want to be, in terms of writing the PhD on the topic I am, because I'm passionate about leaving a legacy that is better than the one I started with.
Very much. There was a speaker up in the red.
I'd just like to begin by saying that I think it's important to remember that Article 12, the energy behind it came from the situations where guardianship had failed people. And I think that it gives us a specific challenge to be creative, that if we think about Article 12 in the old framework, it won't work. We have to shift into a new framework and a new way of thinking about things. And that's very challenging, and challenging for us who are professionals, because instead of people making decisions about those who can't make decisions, they have to think about, how am I going to support this person to make the decisions that they need to make? And that shift, I think, is absolutely critical, that we move away from the denial of rights to the support of rights. And, you know, Martin is sitting beside me here. He wanted to give the example in relation to the query about the dentist. And I think that's a good example about where we need to be creative and thinking about other ways to respond to the same situation. So he was saying maybe the person could have an anaesthetic, and that might help them to get over their fear. Recently I was in Belfast and I met a community dentist who'd come out to your house to treat you. To me, I'd never heard of that before. So we have to think about new ways of working and responding that do relate to individuals and individual needs and support. And just to sort of make the comment of Elizabeth, like your situation in Kenya, where a small number of people are under guardianship. Similarly in Ireland, we're in that situation at the moment. We're at the risk, if the new legislation isn't right, of increasing the number dramatically. Maybe I think the Ward of Court office is currently about 3,000 people. There's potential there could be 30,000 people or more under guardianship orders. So it's really critical, I think, that we use our energy in a very different way than what we've done before. And for me, that's the essential call of Article 12. To respect both parts of personhood, the individual part, and our roles in society part, the two elements of it.
Thank you very much. There's a contributor there in the middle I identified first, and then I'll come up and move up to that corner there. So, no, sorry, there was a woman there with the phone jacket.
Well, I've had my hand up a little bit before that.
Thank you. I wanted to address again this best practice we have heard about from Canada and Australia, I think. Two examples of best practice for supportive decision-making systems. And I would like to know, because we are searching for the best model in Norway too, and I guess all the countries there. And to what extent has these supportive decision-making systems in Canada and Australia learned from those who are supposed to lack capacity themselves? Because what is disturbing me is that we can achieve supportive decision-making systems, but they will be just the same as those substitute decision-making systems if we are not going to learn from those who are supposed to lack capacity, legal capacity themselves. So, and those could be both those people who we know can articulate themselves, gathering those people who are mentally and intellectually disabled, who are supposed to not acting in their best interests. And that could also be those people who have, for a period of time, due to an accident or something like that, been incapable of speech. Because I know people who have, for a while, been unable to speak. And those people have a lot to say about the situation they were in that situation, which can learn us a lot about how they want us to, or the supported decision-making system, to approach them, to handle them, to give the options and to treat them. So I just wondered, do we have any best practice examples from any country which are building upon the experience of disabled people themselves, those who are supposed to lack legal capacity?
Okay, so there are 2 or 3 people who wanted to contribute up in the top corner there, and then I'm going to come back to the panel and to ask them to respond to some of the issues that have been raised.
My name is Christina Bacher, service users, and about the case, about in those situations, they should be given their choice, and in those situations, and in the first place, because as Marie was saying earlier on, in those situations, we should be given a choice in those situations, because it's downright ludicrous if you're going back to the old system, institutionalized situation.
Very good, thank you. Thank you very much. And there are 2 people up in that section of the audience there, to your right. Yeah.
Could I ask the audience members, let's say for example that gentleman who needed teacher care, he developed sepsis, and he needed treatment for that against his will in order to save his life. Would a doctor treating somebody under the doctrine of necessity of common law be in violation of Article 12 of the Young Convention Rights of Persons with Disabilities?
And then immediately behind the last of 2.
Thank you. I'm not fluent in English, so I'll ask help from my colleague Gabriel translate. I will talk in Portuguese. É pouco difícil falar da capacidade legal no nosso contexto africano. It's very difficult to address legal capacity in African context. Num contexto em que, primeiro, a questão da deficiência ainda é tabu. In the first place, because disability is still taboo in Africa. Não é muito difícil olhar só para a televisão, para a rádio, e todos os dias aparecem casos de pessoas com deficiência que vivem acorrentadas. You don't need to see this on TV or hear in the media, because African people, they come across every day when the people are locked away, chained away, so it's a normal way of seeing life in Africa.
Para mim, uma das grandes questões que acho que os outros colegas que falaram sobre o contexto africano tem a ver com a questão da educação.
And from other colleagues who talked about Africa, who preceded me, this issue of disability has to do with education and awareness.
Educação poderá, ao meu ver, garantir esta questão do acesso à informação.
And education will help with people assessing information.
Porque muitas das vezes as pessoas com deficiência não exercem o seu direito. Por não saber que tem um direito, que tem direito de exigir o cumprimento do seu direito.
Because most of the time, people with disability, they don't exercise their rights because they don't know that they have any rights. So are their family.
A outra questão que queria também partilhar tem a ver com a questão que está a ser discutida agora, que é de tomar a decisão em função daquilo que é o melhor interesse da pessoa com deficiência.
Another issue is related with best interest.
O trabalho que temos feito, eu trabalho para o Fórum das Associações Moçambicanas dos Deficientes.
And from my experience, the work I'm doing with the Network of Disability Mozambique,
fazemos ações de sensibilização na comunidade.
we conduct awareness in the community.
E basicamente o que a gente diz é que deve acontecer, que deve levar os nossos filhos com deficiência para a escola. Isto é melhor para o seu futuro, a escola para que estas pessoas no futuro consigam ser autónomas.
And we sensitize them to take also their children to school because that's the best for their independent living, for their future.
Mas depois, em função daquilo que é as condições que prevalecem, que prevalecentes em Moçambique, nas escolas, uma dessas vezes, numa ação de sensibilização, os pais, uma mãe neste caso, o que disse é que como é que eu vou levar o meu filho é cadeirante, como é que eu vou levar o meu filho se a casa de banho, por exemplo, da escola, onde ele está a estudar, primeiro tem sérios problemas de higiene. Então eu levo lá para lá o meu filho e o meu filho corre sérios riscos de apanhar alguma doença.
And the biggest difficulty is my child should have, how can I take my child to school? In the first place, he would need a wheelchair. He doesn't have that wheelchair. Even if he had a wheelchair, there is no tarmac roads or anywhere you can walk with wheelchair. So it's kind of barriers like that will prevent those families taking their children to school.
Está aqui também uma questão de perigo em termos de saúde para esta criança, porque, por exemplo, questões de higiene não estão salvaguardadas nas escolas.
And this increases the barriers because it emerges another needs that need to be addressed before that right it's fulfilled.
Nesta questão é um pouco difícil de continuar com esta abordagem, dizer, ok, leva o seu filho à escola, porque se calhar aquilo que pode ser bom em termos de educação, poderemos estar a colocar em risco a saúde desta criança.
And this way shows clearly that we can continue with our sensitization to take children to school, but before we address the fundamental issues first, this will not be a reality.
Very good. Thank you very much. What I'm going to do now is...
Can I make a point?
Who's that? Yes, sir. I'm going to allow you to make a very brief point. And then after that I'm going to ask the panel. Now, it's 1 o'clock. Would people like to carry on a little bit further with this? Or I mean, I'm going to let you choose, or whether you'd rather go to lunch. Okay, carry on?
Yes.
Okay, okay, we carry on for a bit. Okay, so, oh yeah, sure. Jared, yes. Sorry, if you just come down here. Thank you.
Sorry, I won't hold you up because you have a right to food. Very quick question for the panel, particularly for Rosemary. Sorry, you can get me back later. And it's apropos Elizabeth's point earlier on about informal decision making. When I go home this evening, I'm going to be making spaghetti. I'm not going to consult with my children. I'm not going to be interested in their will and preference. Actually, they're all teenagers, so they're probably always navigating around me anyhow. And it's interesting because a lot of legislation around the world exempts informal decision-making from new legal capacity regimes. And that's important because those tiny decisions, unless you're allowed to make them, you can't build up your capacities through time, and you become progressively de-skilled in some of the most essential life skills. So my question to you, in particular Rosemary, is legislation that purports to exempt informal decision-making, in other words, allow people to make all sorts of informal decision-making, even though you have legal capacity, does that violate Article 12 of the Convention?
Okay, well, Rosemary, do you want to answer that question?
Don't know. I'll give you 5 notes. Does that work as an answer? Informed decision making is such a tricky one. I mean, as Elizabeth so articulately pointed out this morning, that I think the bulk of what goes on in Kenya is probably the bulk of what goes on around the world. Guardianship is a very small element of the exercise of legal capacity for people with disability worldwide. How far can we delve into that private sphere? How much do we want to structure down to those minute elements of a person's life? And I think it comes back to what a colleague of mine has said, that this whole process really needs to be organic. And I know I harp on about this, but it's when we don't see people with disability as others, as different, and that we've got a sense that, and people with disability themselves have got a sense that they can make those decisions, and that, you know, I don't want spaghetti, so I'll just make myself a cheese sandwich before you even get near the kitchen. Until you've got that level of competency to engage those decision-making powers and build on those decision-making powers, I suppose families then can't just take on informal roles and take control. But again, they have to be, the family and the community has to be in a space where they don't just think it's okay to take that informal role and to deny that ability for growth and development. We do it with kids all the time. I mean, whether they've got a disability or not, I'm as guilty as hell for making decisions for my nieces and nephews. Who cares whether they like it or not? He can, you know, sleep at my house. Well, you know, abide by my decisions. You know, it's not a very good answer, and I'm sure learned colleagues on the panel have got a better answer. But I don't think Article 12. I think it would be a shame if Article 12 was used to be more invasive. I don't think, I would be really, really disappointed if people saw Article 12 about creating formal structures around people's lives to that level. I don't know what the rest of the panel.
Anyone else like to come in there?
This is very important, and I think you just tackled the issue that we often don't really allow choices to our children, people who are close to us. But the issue here that we are talking about is that we shouldn't use different parameters if a child has a disability. So if we imply different principles, then it's a problem, and then we are facing a problem in terms of Article 12 of the Convention if we imply double principles to that who is allowed to accept our decision or not. And I wanted to tackle two issues. One is that a few times it was mentioned whether the family should decide or informal supporters, but we are forgetting about many other people surrounding the person. So what about peer support? And that was actually that issue was raised, and we have terrific examples. Since we work with self-advocates a lot, we have terrific examples when they resolved their support they needed with their peers. Their legal capacity was questioned on whether they're able to manipulate with the money, and then they asked their friends to help them to understand the value of money. So they received support, and they argued that their legal capacity shouldn't be taken away. So yes, definitely, work with self-advocates and peer support is very important. And surrounding a person with important people, with people that know her, is definitely what will lead us to a much better place for people to be able to exercise their choice. And another thing is that, and it was raised also, that we have to allow a person to gain skills in decision making. And if we are isolating people either within their families or within institutions, they will never be able to develop skills, to take a risk, to learn from their mistake, and thus become able to make decisions on their own. So really, it's a cross-cutting issue. We have to allow children at the earliest stage to be included in their natural environment, to be able to go to school, to be able to be surrounded by others in the community, so that they can really gain skills that will then allow them to fight for their own choices.
Anyone else
like to
Carlos?
say
Yeah.
Okay, I agree with this one. And yes, I want to ask to this question, and also I think perhaps if I can explain myself to answer some of the questions that the audience make before, or comments that they made before. Because in my point of view, the informal decisions and also the decisions that we can take in a context like a family or a community is not the mean is not all these little decisions or decisions that don't affect very profound, very high to the development of our own personality. So we don't have to accept all the decisions that are going to be made about us, because if we think that we can accept how these decisions are taken, I mean, if I live in a family or I live in a community, I can agree with how the decisions are taken. So I don't have to give an explicit consent to all the decisions that are taken. So what I think is for the family that I said before, the balance is someone say that before, that if the family are the best or the worst, no? Well, the family at the beginning, of course, I think is a very good environment when you can develop your personality. So is the development, is the environment that you have to live, and the decisions are made for your parents, I think is good. But we have to be careful, because we can't go to the myth that all the decisions that the parents take for the children are the best for the children. So because this myth doesn't work. And this is what happened in 1875 with a famous case of Mary Kelly, that she was maltreated for the person who makes like her parents. And the community said, well, we are going to take this child to the court, and they find that there is no law to go against their parents, because we live in a myth that the parents take the best decision always for the children. At the end, Mary Kelly went to the court like animal maltreated, because there was a law that protect the animal against the owner of the animal. So I think, so what I say is, from my point of view, we can relieve at the beginning in the parents, in the family, but the Article 12 what makes is that we have to build a structure, a parallel structure that allow us to go to another place to take decisions if we are not, we don't sit well in our family or in our community, what the other person or the audience say. So you have to take your decision for your own development. So if you are not quite right in your family or in your community, you can go to other place. Why? Because you can exercise your rights, because there is an article now that allows you to exercise your rights.
Thank you. Leanne?
Okay, so in my household, you may put in a bid for what you would like some evening, but everyone eats the same food. I don't run a restaurant. I think we, and that in a way, I mean, I'm not really trivialising, but there are some informal decisions. We all live in relationships. We all live with people. So there are some informal decisions which are clearly inappropriate to apply Article 12 to, except to the extent that we all negotiate when we live with people what goes on. There are other decisions that trouble me a bit, or trouble me a lot, if the informal decision-making process means that people with disabilities aren't making their own decisions. So that whole concept of person responsible that we have, which is kind of to protect the doctors or the service providers, which allows a whole long list of people, theoretically in a kind of order of hierarchy, but not really, to make decisions on behalf. So my daughter lives in a community house with a number of other people. Usually I would accompany her for important medical appointments or whatever, but day-to-day things, someone from her house will go with her. She has a communication disability, amongst other things. I have an issue that if I'm with her, I will engage with a kind of a choice thing, explaining what's going on and breaking it down to get her opinion. But when she's taken with other people, there's no guarantee, and very often something comes back to me. The recent thing is a dental issue. I'm overseas. The dentist has made a recommendation. Everyone wanted to go forward with it because the dentist recommended it. I've said, wait till I'm home, because it's not an emergency and we need to find out what Claire wants to do. So in those informal situations where there are more important decisions, I think Article 12 does have a place. But the difficulty is obviously in distinguishing those important decisions, those kind of decisions, from what's for dinner tonight or what are we watching on television.
Okay, Elizabeth, did you want to come in there?
No, I mean, I wanted to agree with you absolutely, and just to give some closing remarks in response to some of the things that were said. Okay, so I think that from everything we've heard, it's so important to empower grassroots organizations in the context of Africa, particularly if self-advocacy or peer support or other more practical, in that context, supports are going to be provided or are going to be made available. So I think that's one. To the people who are working in those contexts, it's so important to just understand what Article 12 means and then be able to to take that to the ground. And then another thing I'd like to say is the importance of being sensitive to that tension within the family and sort of how that should inform your approach when dealing with families, so that at the back of your mind you know the importance of autonomy and you know that's what you're aiming for, but how to get there, I think it's so important to think about that. And then I just wanted to comment something about Article 32 on international cooperation, because I think there's so much room in this one for developed countries and developing countries to have a dialogue, and I think that expertise on this is lacking so much in a lot of countries, and I mean we are all trying to figure it out, but I'd really like to emphasize that, because I mean, I came to Galway as a result of OSF, and that's how I've ended up going back home and doing some of the work that I'm doing there, so it's important to point that out. Yeah.
Thank you. Well, I think we're reaching our closing phase now. Could I just, first of all, thank all the panel members on your behalf for their super contributions. Could I also thank each one of you who contributed for your revealing and remarkable contributions. There comes a time as a judge when you don't make comments about people, because the comments that have been made speak for themselves. And what is remarkable today is that so many people spoke for themselves and said things much better than other people could ever have said for them. Two things I'd just like to mention. From a judge's point of view, from a court's point of view, I think there remains the question of that very boring word, justiciability. How do you get Article 12 down to dealing with individual concrete cases so that a judge will know what decision to make in accordance with Article 12? As opposed to, and I use the word advisedly, as opposed to applying a best interest test in another guise. And the second thing that question that I think is still there, although many people have answered it in many different ways, is the extent to which Article 12 is not only a statement of principle, but it is also, to use a corny phrase, a journey. In other words, an identification of ways in which people who are involved in decision making, but most of all the people who are the subject of those decisions, can actually engage in the decision-making process. The challenge is, I think, to identify, to use the old phrase, when have we got there? What is the ultimate objective of Article 12? When will we be able to say, yes, those objectives have been fulfilled? For myself, I just want to thank you all very, very much for your super contributions, the panel on your behalf, and Jared for the invitation. Thank you very much indeed.
Just a very practical point before we break for lunch. By the way, we'll come back around 2:15, not 2, because you have a right to eat and a duty to eat. We've just noticed that there's no coffee break listed on the afternoon programme. That's not an example of informal decision-making. To take it off the table is just simple neglectfulness. So we'll have the coffee break right after Eve Hill speaks, and Eve's just arrived. You're very welcome to the room, Eve. It's quite remarkable this afternoon because Eve is, I don't know if any of you have seen the Senate testimony on the ratification of the convention, really a fantastic spokesperson for the convention in a US context. Alongside her, we have people like Camilla Parker, Ines Bullic, Ranvig from Iceland, and our colleagues who are the best of Europe. So we're going to have the best of the United States and the best of Europe this afternoon. And if you're walking the promenade here in Galway, which is beside the seaside, we generally say next stop Boston. So this transatlantic bridge is quite important to us. So enjoy your lunch, and thank you very much again, panel and Justice MacMenamin. Thank you.